morning, everybody. Now let's get straight into the stories. There's two big announcements that came out from the FSCA this week. The first one was that it imposed an administrative penalty of, and I kid you not, in the press release of the FSCA, they actually wrote out the amount, like in words, because it's so big. So let me read it to you. The administrative penalty that they instituted was 358,750,000 rand. That was on Mr. Stefanus Johannes Stian Grobler, that was actually responsible for the financial statements of SAAF International Holdings for the 2014, 2015, and 2016 financial years and the 2017 half year. The investigation found that he contravened sections 81(1)(a) and (b) of the Financial Markets Act. These provisions prohibit the direct or indirect making or publication of false, misleading, or deceptive statements. Now, obviously, the financial statements issued by SAAF during that relevant period were false, misleading, and deceptive in respect of material facts that were either misstated or omitted. And he, Mr. Grobler, served as the company's secretary, the head of treasury, and the in-house legal counsel of the SAAF group at that time. And he was a director of several subsidiary companies. That is an enormous amount of money that will have to be paid. Whether it's going to happen is open for discussion, but let's see how that goes. Then, secondly, the Financial Sector Conduct Authority also concluded an investigation into the conduct of the South African Army Foundation and two of its senior officials. This was conducted in terms of the Financial Sector Regulation Act, specifically Section 135(1). The authority is currently considering the appropriate enforcement action to be taken. This investigation started following a referral that was received from the Specialized Commercial Crime Unit. So it will be interesting to see which considerations and further communication we will get about this. But there will probably be criminal proceedings that are linked to it, but the FSCA is not in a position to comment on this. It is actually interesting that they are starting to act in this manner as well, and not just through administrative penalties and fines. So keep an eye on this. I think it's going to be interesting to see where we go. Then one other thing that I found in IOL actually is that there is currently an appeal ongoing by a financial advisor who sought to block his debarment proceedings. Now, this was instituted against him by Carrick Wealth, and the appellant, Mr. Maynard, was employed as a representative of this firm until October 2023. Now, while he was serving his notice period, he emailed confidential client information, including the names and asset values of about 80 clients, to a former colleague who was then working for a direct competitor. Now, this breach of confidential client information got him debarred after he finished up with Carrick Wealth. And Mr. Maynard then went to court and claimed that he wished to buy out these client details, but he did not obtain consent from either the clients or Carrick Wealth prior to disclosing this information. He then appealed the debarment. It was first struck down, or the initial court struck it down and didn't tell him that he should be reinstated. It then took it on appeal, and it seems that he has lost the second appeal as well. So this is actually an interesting case to see that he had to be debarred and that they acted in the right manner, and that the court confirmed that. So from FPI's side, we had our first annual refresher in Cape Town. It was a roaring success. If you want to visit us, there will be a virtual annual refresher if you stay somewhere else and you can't meet us in person. So the registrations for that is also still open. So please join us for that. And then on that note, see you again next week.